mistake. I'm only 19 years old.
Shall be executed in a method provided by Florida law.
We're having fun in a f***ing cop car.
Yep. Tristan.
What's up, guys?
Yep.
Tristan, if you f***ing walk out the damn...
When you see this in a month.
This is no joke. This is your whole life. Your whole life.
You don't know me, but you tried to kill me.
Austin Myers.
The trial took weeks. His verdict was handed down in hours.
We, the jury, find Austin Gregory Myers guilty beyond a reasonable doubt of aggravated murder as charged in...
At 19 years old, was sentenced to death in Ohio for his involvement in the brutal murder of Justin Back, a crime that shocked the small town of Waynesville in 2014. Myers, along with his accomplice Timothy Mosley, planned to rob Back, who had recently graduated from high school. The two men lured Back to his home under the pretense of a social visit. Once inside, the situation turned violent. Myers and Mosley attempted to strangle Back with a choke wire, but when that failed, Mosley escalated the violence by stabbing the victim multiple times. The two men then wrapped Back's body in a blanket and disposed of it in a rural septic tank. They also stole items from the victim's home, including a safe, and attempted to destroy evidence by setting it on fire.
Timothy Mosley killed 18-year-old Justin Back in January of last year.
Obviously, we're satisfied. We think that justice was served today.
Myers and Mosley carried out a planned burglary at Back's home, strangling the Waynesville High School graduate and dousing his body with septic system enzymes before dumping it in a wooded area.
The prosecution's case was built on the cold and premeditated nature of the crime. Despite the defense's arguments that Myers was not the primary aggressor and had not intended to kill Back, the jury convicted him of aggravated murder, robbery, and tampering with evidence. Myers' sentencing was controversial due to his young age and relatively clean criminal history. His defense attorneys pointed to his immaturity and lack of life experience, arguing that his brain was still developing, which might have impaired his judgment and decision-making. However, the jury found the brutal nature of the crime, the planning, and the execution of the murder to be aggravating factors that outweighed any mitigating circumstances. Myers was sentenced to death in 2015, making him one of the youngest people in Ohio to receive a death sentence.
Now the youngest person on death row in Ohio.
The idea that he has no worth or value as a human being, so better off euthanized.
For the brutal murder of a friend.
We have memories, but we will have no more with our son because of the choices that you made, Austin.
And tonight, a bombshell revealed in court.
No, I've made a horrible mistake. I'm only 19 years old. I think there's a lot of good things I can do with my life if you allow me to keep my life.
Judge Don Oda upheld the jury's recommendation and sentenced Myers to death.
The defendant does not understand how precious life is.
After sentencing, prosecutor David Fornshell revealed more details about Myers' plan.
His case sparked debates about the ethics of imposing the death penalty on individuals who are still technically adolescents. Critics argued that at 19, Myers was still in a critical developmental stage, and brain research suggests that young adults often lack the full cognitive ability to understand the consequences of their actions. Despite appeals to reconsider his sentence, the Ohio Supreme Court upheld the death penalty, and Myers remains on death row, his case continuing to be a focal point in discussions about juvenile justice. Marlon Joseph.
This process was a qualitative process and not a quantitative one. Understanding that process, this court then assigned an appropriate weight to each aggravating factor and determined they are singularly and in combination with each other more than sufficient to justify a sentence of death as to each count of first-degree murder in this case. Having determined that the proven aggravating factors are sufficient, the court then undertook the weighing of the proven aggravating factors against the established mitigating circumstances. The court finds that as to each count of first-degree murder considered separately, the proven aggravating factors overwhelm the established mitigating circumstances. Moreover, this court recognizes it must give great weight to the jury's recommendation of death. This court wholly agrees with the jury's unanimous recommendation based on an independent review and assessment of the aggravating factors and mitigating circumstances presented. This court finds the aggravating factors heavily outweigh the mitigating circumstances and that death is the proper penalty for the first-degree premeditated murder of Claude Crowell and for the first-degree premeditated murder of Kira England.
In 2020, Marlon Joseph was sentenced to death in Florida for the brutal murders of Khalida Crowell, 33, and her 11-year-old daughter, Kira Inglet, in 2017. Joseph, who had been dating Crowell and living in her home at the time, became enraged during a heated argument with Crowell. The altercation quickly turned violent when Joseph shot Crowell in the head, killing her instantly. He then chased Kira outside, where he shot her multiple times despite the girl's desperate pleas for her life. The senseless nature of the murders horrified the community, and Joseph's lack of remorse further exacerbated the shock of the crime.
But under the laws of the state of Florida, you have forfeited your right to live at all. Accordingly, it is hereby ordered and adjudged that, as to count 1, for the first-degree murder of Claude Crowell, Marlon Maurice Joseph shall be delivered into the custody of the Florida Department of Corrections at the Florida State Prison. You shall be confined there until a date certain selected by the governor of the state of Florida, and on that date you shall be executed in a method provided by Florida law.
Joseph's defense attorneys argued that his difficult upbringing and mental health issues, including depression and post-traumatic stress disorder, should mitigate his responsibility for the murders. His childhood was marked by neglect and trauma, and his legal team contended that these factors played a role in his violent outburst. However, the jury found that the brutal and premeditated nature of the killings outweighed any potential mitigating circumstances. The prosecution emphasized Joseph's complete disregard for human life and the cold-blooded execution of both victims.
Video you'll see only on 5, police escorting Marlon Joseph, the man accused of murdering a West Palm Beach mother and daughter.
In addition to the shocking nature of the crime, Joseph's case sparked a broader conversation about the intersection of mental health issues and criminal responsibility. His defense attorneys argued that he was not mentally competent at the time of the killings, but the jury rejected this argument and convicted him on 2 counts of first-degree murder. The sentencing phase of the trial included testimony about his difficult upbringing, but ultimately the aggravating circumstances, including the cold-blooded nature of the murders and the fact that the victims were defenseless, led to his death sentence. Dexter Johnson.
Dexter Darnell Johnson, the jury has found you guilty of capital murder. In accordance with the laws of the state of Texas, this court hereby assesses your punishment of death. Ladies and gentlemen of the jury, this is going to complete your jury service. I'm going to meet you in the jury room.
An 18-year-old from Texas was sentenced to death in 2007 for his involvement in a double homicide that occurred during a botched robbery. In 2006, Johnson, along with 2 accomplices, kidnapped Maria Aparis and her boyfriend Hui Ngo, forced them into a remote area, and executed them by shooting them multiple times. The couple had been carjacked and held hostage, and Johnson was the ringleader of the crime. Despite the fact that the couple was defenseless and pleaded for their lives, Johnson showed no remorse for his actions, and the killings were deemed especially heinous and cruel.
All rise.
During the trial, Johnson's defense team argued that he had intellectual disabilities and that his actions were influenced by his limited cognitive functioning. They presented evidence of his troubled background and his struggles in school, hoping to spare him from the death penalty. However, the jury found that Johnson did not meet the legal requirements for an exemption from the death penalty due to intellectual disability, as defined in Atkins v. Virginia, 2002. Despite the defense's claims, the prosecution emphasized the brutal nature of the murders and the fact that Johnson had planned and carried out the killings with complete disregard for human life.
See you, ladies and gentlemen.
Johnson's conviction and sentence have sparked debates over the execution of individuals with intellectual disabilities, as well as the appropriateness of the death penalty for young offenders. His case is part of a larger, ongoing conversation about the moral and legal implications of capital punishment, particularly for those who may not fully understand the consequences of their actions due to mental impairments. Johnson remains on death row, with his case continuing to draw attention to the complexities of sentencing young offenders who may have cognitive impairments. Aiden Fucci.
We're having fun in a f***ing cop car.
Yep. Tristan.
What's up, guys?
Yep.
Tristan, if you f***ing walk out the damn...
When you see this in a month...
I would submit that this case is probably the most difficult and shocking case that this county in St. Johns County has dealt with. In the 20 years that I have been, or 16 years that I have been practicing law.
Aiden Fucci, a 14-year-old from Florida, shocked the nation with the brutal murder of his 13-year-old schoolmate, Tristan Bailey, in 2021. Fucci and Bailey were classmates at Patriot Oaks Academy, and their tragic encounter occurred when Fucci lured Bailey into the woods near their neighborhood. Once there, he repeatedly stabbed her 114 times, leaving her body in a wooded area. The crime was premeditated, as Fucci had posted a disturbing photograph of himself on social media just before the killing, showing him with a smirk and holding a knife.
The Snapchat that you did was not very smart.
Not gonna put it on. Now we have people want to burn our house down and our cars down. Because of that Snapchat thing you did. It's all over, you're all over the internet and everywhere. Social media.
It's on social media. You're probably gonna stay with me after we get done with this. Just for your well-safe being.
This is serious.
It's very serious.
This is no joke. This is your whole life. Your whole life.
And yours.
And ours. And your brothers and sisters. And don't forget to get us wrong. Because the kids will learn them.
The brutal nature of the crime, combined with Fucci's apparent lack of remorse, made the case especially shocking, as the victim was his peer, and the murder was committed by a young teenager. Despite his young age, Fucci was charged as an adult and faced the possibility of life in prison without parole. The case also raised important legal and moral questions regarding the sentencing of minors who commit such heinous acts. While minors are constitutionally exempt from the death penalty under Roper v. Simmons, 2005, Fucci was eligible for a life sentence due to the severity of the crime.
What's going on? I don't let you demons. I don't let you demons take my soul. You demons want to take my soul away. I don't let you demons steal my soul. I don't know what's going on. What? I see you face. What's going on? What you got going on? Why am I here? I just want to talk to my mom and dad. What's going on? What's going on? What's going on? What? I used to. Why am I in this change?
And Mr. Fucci just wanted to make a short statement.
I just want to say I played out guilty. And I'm sorry for the Bailey family and my family.
I'm sure there'll be an opportunity, obviously, a sentencing hearing to speak
Yes, sir.
In 2023, Fucci pled guilty to first-degree murder and was sentenced to life in prison without the possibility of parole. His case has sparked a broader conversation about juvenile justice, particularly concerning the capacity of young offenders to understand the consequences of their actions and the potential for rehabilitation. Despite his age, Fucci's actions and the brutal nature of the crime have made it clear that there is a need for a careful evaluation of how young offenders should be sentenced for violent crimes. His case remains a key example of the challenges facing the criminal justice system in handling extreme juvenile crimes. Nicholas Cruz.
Previously waived, then there was some discussion about whether it could be in a death penalty case, but
Nicholas Cruz was 19 years old when he carried out the devastating 2018 Parkland school shooting at Marjorie Stoneman Douglas High School in Florida. Cruz, armed with an AR-15 style rifle, killed 17 people and wounded 17 others in a calculated attack that shocked the nation. He had been expelled from the school for disciplinary reasons, and his history of behavioral issues, including threats of violence, had raised concerns prior to the shooting. Cruz's actions were premeditated, and he made no attempt to conceal his identity or escape the scene, making it clear that he intended to carry out a mass murder.
when these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Miss McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it.
Sentencing phase of his trial began in 2022, where the jury was tasked with determining whether Cruz should receive the death penalty. However, despite the severity of his crime, the jury was unable to reach a unanimous decision, which is required for a death sentence under Florida law. As a result, Cruz was sentenced to life in prison without the possibility of parole.
You don't know me, but you tried to kill me. I will have a scar on my arm in the memory of you pointing your gun at me, ingrained in my brain forever. The person I was at 2:20 on Wednesday, February 14th, 2018, is not the same one who stands here today. I am broken and altered, and I will never look at the world the same way again.
Cruz's case reignited the national debate over gun control, school safety, and the appropriateness of the death penalty for individuals who are still relatively young, especially in light of Cruz's history of mental health issues. His defense team argued that he should not be executed due to his troubled upbringing, mental health issues, and the trauma he had experienced in his Jonathan Belton.
When Oakland County Judge Ray Lee Chabot warned attorneys that if anyone used the word polygraph, as Jeffrey Feiger did on Monday, they'd be going to jail. Polygraphs are not allowed in Michigan courts, and referencing them isn't permitted either.
If the word polygraph is used in this trial again, either by Mr. Feiger or Mr. Frazee or any of their witnesses, I am going to grant the mistrial. I will swear out contempt. And the sanction isn't going to be money, it's going to be jail.
Today's testimony...
Jonathan Belton was 16 years old when he committed the 2004 murder of Detroit police officer Larry Nevers, an act that would shape his future and the legal landscape for juveniles in Michigan. Belton, along with an accomplice, ambushed Nevers while he was on duty, resulting the officer's death. Belton and his accomplice shot Nevers multiple times during a confrontation, and despite Nevers' attempts to defend himself, he succumbed to his injuries. The killing shocked the Detroit community as it was a brazen attack on a police officer. Belton was quickly arrested and charged with first-degree murder, and at 16, he was tried as an adult, which led to his conviction.
Teenager Jonathan Belton shot the Oak Park officer at an apartment building following a traffic stop in 2008. A forensic lab specialist testified why Samborski's gun belt was never tested for prints.
The actual texture of the surface, it's not like a flat window. It's not like a flat piece of glass. It's not like a flat piece of metal. It's very textured and it has a rough surface to it, which makes it very difficult to develop latent fingerprints on.
Defense attorney Jeffrey Feiger claims Samborski shot himself during a struggle, and he raised several questions about the work of the forensic lab, including why some of the blood found in the apartment complex was never tested, why 2 carpets weren't tested until a year and a half after the shooting, and why at least 1 report may be missing.
Because there is evidence in this case that you decided, or your lab decided, to keep secret. Isn't it true?
Belton's case became significant not only because of the nature of the crime, but also because of its role in shaping the debate over juvenile sentencing. Initially, Belton was sentenced to life in prison without the possibility of parole, which was a common practice for juveniles convicted of serious crimes at the time. However, in 2012, the U.S. Supreme Court issued a landmark ruling in Miller v. Alabama, which prohibited mandatory life sentences without the possibility of parole for juveniles. This decision was based on the understanding that juveniles have a greater capacity for rehabilitation and should not be subjected to the harshest sentences without considering their age, maturity, and potential for change. As a result of this ruling, Belton's sentence was revisited. He became one of the many juvenile offenders whose life sentence was reevaluated under Miller v. Alabama. While his case did not result in a reversal of his conviction, it underscored the ongoing national conversation about how to treat young offenders. The Miller decision opened the door for reviews of life sentences for juveniles across the country, allowing courts to consider mitigating factors such as the offender's age, mental state, and capacity for rehabilitation.